SJC-12297, Scavenger Inc. v. Punch Inc.
Good morning, Mr. Carroll. We think it's an important case, even if the crowds don't seem to be flocking. So
That's okay, Ron.
we know it's important.
May it please the court, Brian Carroll, on behalf of Scavenger Inc., doing business as Level Up. It is a pleasure to be here addressing the court on an issue as important and broadly applicable as personal jurisdiction. This case, this defamation case, presents the court with a more narrow application of those broad principles, and one that I think has some unique considerations, but is nonetheless very important to Massachusetts businesses, and particularly businesses like Level Up. The question specifically presented in this case is, can a Massachusetts court exercise personal jurisdiction over a corporate defendant engaged in a nationwide campaign of defamation targeted at the Massachusetts operations of a Massachusetts business with the sole and express purpose of winning customers and winning business away from Massachusetts?
Okay, can we unpack that just factually a little bit?
Sure.
What was the nature of the campaign? Was it all done through the internet?
The campaign in this case was a combination of oral conversations, mostly by telephone, I believe, and emails. So there were no generally broadcast internet postings. This wasn't a case where the competitor was out publishing on websites or publishing on a blog. These were targeted communications, and they were targeted specifically to businesses that either had contracted with Level Up for services in Massachusetts, or that Level Up was treating as prospective customers and discussing a contractual relationship.
So none of the telephone calls, though, were to anyone in Massachusetts, and none of the emails were to anyone in Massachusetts.
So we've alleged in the complaint that we believe that, given the nature of the campaign and the nature of the context, that there were also contacts in Massachusetts. There's no evidence in the record to show that there were any specific, that any of the recipients received a phone call in Massachusetts or received an email, opened their email in Massachusetts. But there certainly is evidence that those recipients were the business people responsible for business operations that included restaurant operations in Massachusetts.
But the decision makers were not necessarily, I mean, whoever was going to decide who to contract with, whether it was your client or Punch, wasn't necessarily in Massachusetts.
For the entities that we know of, that we've alleged specifically, the headquarters of those operations were not located in Massachusetts. Where the individuals happened to be when they opened their email or received their phone call is a matter that there's no information
No, I understand that,
on.
but I'm just saying that there was nothing to suggest that the people, I mean, if it was targeted presumably at the people who'd make the decisions about who to contract with, right?
Yes, it was targeted to the decision makers, to the, whether that's the marketing officer or the chief financial officer.
Right,
or CEO.
so the fact that they might have had restaurants and so forth in Massachusetts wouldn't have made the people in Massachusetts the decision makers.
But like I said, the record's silent as to where the recipients
I know,
were.
but didn't you have a
but
burden?
the headquarters of the entities that they represent were certainly outside Massachusetts.
Okay.
And there's no allegation that any of those people were physically in Massachusetts. We just don't know. But I'd say, it's certainly not impossible that they could have been, when they received the email, visiting one of their restaurant locations in Massachusetts. I'd suggest to the court that that is not the relevant consideration in this defamation case.
Well, what were the minimum contacts here between the defendant and the Commonwealth?
So the minimum contacts in a defamation case focus on not the physical receipt of the message, but the focus of the defendant in making those contacts, and whether the defendant aimed those defamatory statements at Massachusetts. So again,
You're basing that on Calder, right? Calder
that's
versus Jones?
that's based on the express language of Calder, both the focus and the express aiming, and the facts that go into that to determine whether there was express aiming are ample in this case. So, for example, the defamatory statements in this case were all specifically about activities that occur in Massachusetts. Level Up is based here in Boston. All of its employees relevant to this case are here in Boston. And making accusations about the way that Level Up treats confidential information and treats its clients' confidential information go directly to the security and integrity of those Boston operations. The defamation that we've alleged in this case included not just statements about how Level Up treats its clients' information, but also specific statements about, false statements about Level Up's contracts, its user terms, and its contracts with customers that are all expressly based in Massachusetts
Those are
law.
the plaintiff's acts in Massachusetts.
No, these are the defendant making statements about
About the plaintiff's
contracts
acts.
that are governed by Massachusetts law, false statements about those.
Right, but I mean, they're making false statements about what supposedly happens in Massachusetts, right?
Yes.
But it's what the plaintiffs are doing in Massachusetts, not what the defendants are doing in Massachusetts.
That's correct. The defendants are making those statements. The subject of the defamation is activities occurring within the Commonwealth. The defendant in this case implied falsely or stated falsely that Level Up had been sued by clients. I think that implies legal action in the Massachusetts courts. And I think perhaps most importantly, the defamation in this case was specifically targeted, again, not broadcast to a general audience outside Massachusetts, but targeted to potential customers that had entered into services contracts in Massachusetts governed by Massachusetts law. More than half of the recipients of the defamation were Level Up customers, and they only were receiving those statements because they had entered into these Massachusetts contracts for this Massachusetts service.
We could argue without too much dispute that your contention is based on the harm done to your client in Massachusetts, that the effects, that the harm suffered happened in Massachusetts. But beyond that, I'm having trouble understanding how this is like the Shirley Jones matter, where the story was a National Enquirer story, concerned her activities. She was a California resident. It was about her California activities. Her career was in California. The article was drawn from California sources. And the story was published and circulated in California. So that's a set of contacts between the defendants and California that don't really exist here.
So
In addition to the fact, of course, that they said in some California is a focal point both of the story and of the harm suffered.
So to start at the beginning, I think harm is certainly a factor, but we've never alleged that jurisdiction arises in this case strictly because Level Up happened to be in Massachusetts, and that happened to be where the harm was. For example, if this were some other tort case, not a defamation case, let's say Punch had hired a Level Up employee in California and acquired confidential information that way. If they had downloaded an app from the App Store, a Level Up app in California, and copied it and committed a copyright infringement, those types of acts wouldn't have any connection to Massachusetts. Those are acts that Punch did in California, strictly in California. Defamation is, as was laid out in Calder and by the Supreme Court in Walden, a different animal. And it's because expressly, in these cases, the plaintiff, Level Up, is the focus of the defendant out of which the tort arises. So the defendant chooses, in this case, to attack Level Up in Massachusetts, to make false statements about what Level Up is doing in Massachusetts, the service it's providing. And I think importantly, it's targeting not the recipients. So when Punch goes to a client that's headquartered in Texas, that is a client of Level Up, that has restaurants all over the country, but its headquarters are down there, they're not seeking to defame Level Up's reputation in Texas. They don't care particularly about Level Up's business reputation in Texas. What they're trying to do is interfere in that contract between the Texas entity and Level Up in Massachusetts. That's a contract formed in Massachusetts law. That's a revenue stream that flows from all over the United States, including locations in Massachusetts, up to Level Up in Massachusetts. And they're seeking to divert that revenue stream away from Massachusetts to California. And these are all affirmative, knowing, intentional acts by the defendant towards Massachusetts that in a way that other torts may be committed in California or not.
So let's imagine it's 1985, and this happens. Well, assuming there were apps in 1985, but you would cite Calder versus Jones. Calder versus Jones focuses on the focal point of the story and of the harm suffered. Shirley Jones was in California. The focal point of the story was in California. Her harm was suffered in California. And the court did not really focus much, if at all, on the publication because the National Enquirer was not, at that time, a defendant. What do we do with the Justice Thomas's interpretation of Calder versus Jones in 2014, where that interpretation may not actually be one that is a fair one. Do we say that the U.S. Supreme Court's inaccurate characterization of what it did in 1984 is now what the Supreme Court says, or do we say the opinion stands for itself and we're not going to rest on Justice Thomas's inaccurate characterization of what that opinion was?
Sure. To the first point, the inquirer actually was a defendant in that Calder case. They had just assented to jurisdiction, so they weren't part of the
They were not part of
appeal.
the issue, okay. But the issue of jurisdiction was about the author and about the publisher, not about the National Enquirer.
Right. It was really about the individuals because they were able to make an argument that said, well, we didn't publish the story in California. And the court said, well, for a lot of reasons, including that you drew the information from California sources, you knew that it would harm her in California, and you knew it would be published and harm her, then you're still responsible. I don't think that Justice Thomas in Walden was revising Calder necessarily. I agree that Calder was not focused on the location of the publication in a way that...
On the issue of publication as being the determinative factor.
Justice Thomas in Walden does give the location of publication much more weight in Walden, but I don't think that in 2014 that case necessarily turns in any part on technology and the evolution of technology or the Supreme Court's view of Calder. I mean, certainly Justice Thomas says that Calder remains good law, and Calder was decided primarily as because of the function of the features of the libel tort and because of the nature of that tort and a lot of factors that weren't present in Walden. So recall in Walden that interaction grew out of a physical interaction between two individuals that happened in Georgia. So this was not the defendant seeking out the plaintiff with defamation. These were statements about an activity that happened in the Atlanta airport and the seizure of cash that at all times remained in Georgia. So what Justice Thomas said here is that the nature of the injury in this case is much different than in Calder. In Calder, the injury was reputational, and it damaged that person in California. Here, the injury was access to cash, and the plaintiffs happened to go to Nevada and seek to access their cash, and that's why the injury was felt there. But they very well could have gone to Minnesota and sought to access their cash, and the injury would have been in Minnesota. So these are all unilateral acts of the plaintiff that move the harm around the country. Whereas in Calder, it was very clear that they were focusing on causing that harm in California. And that really is the critical difference between those two cases, and it's the reason that Calder controls in this case. Because Punch did affirmatively seek out Level Up, did make statements about its Massachusetts operations, and specifically targeted those customers that were engaged in service contracts with Level Up in Massachusetts. So it's the Massachusetts business that they're going after and they're targeting in a way that, like I said earlier in my example, wouldn't occur if it were activity, a tort that Punch caused strictly by something it did in California, by downloading and copying an app, or by hiring an employee strictly in California.
Well, they're not targeting Massachusetts, right? It's sort of amorphous. They're trying to get business. Does that mean they have jurisdiction everywhere? Any defendant in any state would have. They're trying to get business all over the place, right?
Well, they're trying to get business certainly all over the place. In this particular case, they're trying to win business away from Level Up. They're not just broadly publicizing defamation about Level Up to anyone who'll listen. They're targeting companies that either do business with Level Up or about to do business with Level Up. And I do think it is a state-by-state inquiry, and it needs to be under Calder to determine whether the focus of the defamation and the aiming of the tort was at that state. So in this case, we've got evidence that one of the recipients was located in Wyoming. And under the test proposed by Punch and possibly as adopted by the court, there was a statement received in Wyoming. We could go to Wyoming because there was a statement received there and file an action, but surely no one would say that Wyoming was the focus of this defamation in any way. So back to the fundamental holding of Calder, a Massachusetts plaintiff should not have to go to a California court to defend itself against California defendants that, though remaining in California, are targeting and causing all the harm in Massachusetts.
Yeah, I assume if you were headquartered in New York, you would not be here.
Well, sure, if we were headquartered in New York, there were statements received in New York, and it seems like the parties would agree that the case could be filed there.
So does that mean whenever a Massachusetts corporation's attacked financially, someone's trying to, you're in a really competitive world now, the internet world. So whenever a Massachusetts corporation, someone spreads stuff about them, you automatically have jurisdiction in Massachusetts?
No, I don't think that's the case at all.
And why wouldn't that? Because it sounds like pretty much, there's no, besides that earlier phone call 2 years earlier and their earlier financial arrangement, which seems important to me, but you're not stressing that. This is just like any other sort of attack on a business, isn't it?
So I'll get to the earlier relationship if I could in a second, but I think more generally to the point, there certainly can be defamation against companies that doesn't fall into this focused, aimed type of defamation. So if a website, a broadly read website throughout the United States, publishes a false story about a company, that, depending on what that is, that's not necessarily focused.
No, I'm talking about just this kind of thing, this sort of telephone attack. But basically, you've got two competitors and one's calling up the other, its clients and potential clients, to undermine the Massachusetts company. That seems probably happening all the time, everywhere in this world. I'm just trying to understand why this case is different from that. Basically bad competitive information, and does it always provide jurisdiction to Massachusetts companies when that happens?
Again, I'd say no, and I think it depends on the nature of the defamation. Are we talking about a California company and a Massachusetts company, where the California company goes to a local California business and makes a statement that, hey, the last time a Level Up sales rep was in California, he committed this horrible act in California.
That's different, though. I'm just talking about the normal stuff here. Business undermining each other's, product. Which, the sales guys call up, their contacts in the different companies and say bad things about. It just seems like that happens a lot. And I'm just trying to understand, is that always providing jurisdiction when, when someone calls up and undermines and says something bad about any Massachusetts corporation, does that provide jurisdiction in Massachusetts? Because that seems like what you've got here.
So again, I think that it is always case specific. So certainly I wouldn't say that in every case, calling up the clients of a competitor and making false statements about them would give rise to jurisdiction.
Why is that? I don't mean to belabor this point, but so if someone makes the 7 phone calls outside of Massachusetts to the directors of purchasing at some internet company or some high-tech company, and says something bad about a Massachusetts company to shift the business there, is that enough to provide jurisdiction in your view?
So I think what you'd look at in applying the test, and I don't think it particularly matters whether that person who receives the call is inside or outside Massachusetts, if they've got a relationship with a Massachusetts company, and that person is making statements about the Massachusetts company that are false, that are for the intent of interfering in that contract that's formed in Massachusetts, that are for the purpose of pulling that business out of Massachusetts, that person who's calling and making those false statements is making an affirmative, knowing decision to reach into Massachusetts, into the economic life of the Commonwealth, to participate in the economics in the Commonwealth, and to do it in a tortious way. And yes, that would give rise to personal jurisdiction in that case.
Even though they've never been here and all they did was make a phone call from California to couple of Hawaii or, California or Texas companies.
Well, I mean, sure. Take the reverse example. Let's say my intent is to use defamation to really hurt Punch's business in California. Mm-hmm. It doesn't matter. I'm not going to.
They don't care where the business is. They just want the dollars, right? So
right.
They're just trying to attack their competitor.
Sure. I'm going to attack my competitor. I want to hurt their business. It doesn't do me any good to publish statements. I'm going to go after your clients. I'm going to go after the revenue streams that flow into California.
Isn't that what every sales rep is doing around the country right today?
Sure. But I think if you're going after a competitor's business, and there's no dispute that they know that Level Up is a Massachusetts business, and this gets us back to the point about the earlier relationship, which is And this is a compounding factor in this case that supports jurisdiction, which is Punch had this relationship with Level Up for over a year. They had this close familiarity. They published this to the marketplace, that they were a partner of Level Up. They drew information from Level Up, and then were able to use that to strengthen the defamation, again, in a contract, the relationship that was formed in Massachusetts is subject to Massachusetts law. But I do think that if you're a salesperson, you're going after trying to harm a competitor located in a foreign jurisdiction, you're doing it by attacking the revenue streams that flow into that jurisdiction, that you're doing business in that jurisdiction, and you're committing a tort in the context of doing business in that jurisdiction, and that gives rise to jurisdiction.
Is it only, does this really just apply to defamation?
I think that we've certainly addressed defamation in this case because that's how it arises.
I know, but I mean, is it because of the nature of the injury that defamation does that this is almost like a defamation carve-out?
We had this discussion at the trial court, and I do think that this is effectively a defamation carve-out. I haven't given much thought to whether there are other torts that might have a similar approach, but the point and the reason that it's a carve-out is because defamation is a tort that lends itself to being committed and causing harm from far away, and we can do that via the internet and via email and via telephone. It's the nature of the injury and the nature of the tort that the court was focused on in Calder, which is why we have a more narrow application in defamation cases, or a more unique application, I should say.
Okay, thank you.
Thank you.
Mr. Pyle, still good morning.
Good morning. May it please the court, Jeffrey Pyle for the defendant, Punch, Inc. The question in this case is whether a small California company can be sued here for allegedly defamatory statements that were never published in Massachusetts, and the answer has to be no. The fact that the statements were about Level Up, a Massachusetts resident, and the fact that Level Up happens to have its headquarters here doesn't establish minimum contacts between Punch and the Commonwealth of Massachusetts. And the fundamental tenet of due process is that for specific jurisdiction to attach, the claim has to arise out of or relate to the defendant's contacts with the forum state.
So does it change at all if, for example, you have an internet site that is a promotion campaign that makes defamatory statements, and you haven't exactly published it in Massachusetts, it's on your own website. People come to look at it. Is that any different?
Under certain circumstances, an internet defamation may meet the arising out of or relating to prong of the due process analysis, in the sense that the tort arises out of, to some extent, publication within the forum state. But it would depend on the facts as to whether or not it meets the purposeful availment test that is also part of the due process analysis. In fact, in the Noonan versus Winston case, you had the First Circuit looking at an ad campaign in the pre-internet days, to be sure, but where 300 copies of an allegedly defamatory ad were circulated within Massachusetts. And the First Circuit said that's not purposeful availment because it was really intended for a French audience. So the mere fact of publication within the forum state isn't the only question.
Okay, so that would answer my next question, I think, which would be that if, for example, you send an email to the decision maker, or well, somebody who's in the headquarters of a company that you really would like to, they're doing, let's assume this person, this company is located in Texas, and the Texas company has a contract with your competitor that you would very much like to have. So you send an email to that company headquartered in Texas, and you make defamatory statements about your competitor. But that's not really where the decision maker happens to be located. The decision maker actually happens to be located in Massachusetts, and it's forwarded to the decision maker in Massachusetts.
The decision maker of the Texas corporation happens to be located in Massachusetts.
Yes.
Under those circumstances, I again have a hard time understanding how the claim arises out of or relates to a volitional decision by Punch to reach into Massachusetts and purposely avail itself of the privilege of conducting activities within Massachusetts. It's communicating with Texas. The alleged defamation is published only in Texas. The tort does not occur in Massachusetts because, of course, in a libel claim, publication is an essential element of the tort of libel. The tort doesn't occur in Massachusetts. And that really distinguishes this case in a broader sense from Calder, which is the best case I think that Level Up really has.
It's the only defamation case that I'm aware of.
The only Supreme Court defamation case on the subject, except for Keaton against Hustler, which was decided the same day as Calder. And in fact, the Keaton court said, we generally think of libel as occurring wherever the allegedly defamatory material is circulated. There, in that case, a woman plaintiff chose to sue Hustler in New Hampshire because New Hampshire happened to have the longest statute of limitations for a libel claim, the only one that she met. And the court found there was jurisdiction in New Hampshire, regardless of the fact the communications weren't focused there, because the Hustler magazine circulated about 10 to 15,000 copies within New Hampshire, and it focused on the fact that the tort occurred in the forum state. In Calder as well, the court focused on the fact that the reputational injury, which is the essence, again, of libel damages, occurred within the state of California, because the National Enquirer circulated 600,000 copies within that jurisdiction. That was double its circulation within the next broadest circulation
So
state.
the reputational injury happened in the state in which it was also publication?
Yes, in Calder, but not here.
No, I understand that, but you're saying it's the two things together?
It's, in fact, four things that Calder, at least as either reinterpreted or glossed upon by the Walden case, really focuses on. First, as I mentioned, the tort occurred in California. Second, the fact that the defendants who were located in Florida deliberately reached out into California and made phone calls to obtain the information that they then used in the allegedly defamatory article. That factor, again, is absent here. There's some mention here of an earlier contract between the parties.
But where is the reputational injury here then?
There
Because if you assume it is a tort, and they're injured somewhere, where are they injured?
They're injured among the parties to whom the defamatory content was published.
Wait. So is it your position that, let's assume Scavenger had one client in California. All their business came from one client. You go to that client and you say, this company is run by white supremacists, you should not be dealing with them. They cut off the contract. Everybody in Massachusetts loses their job. We got 40 people in Massachusetts who've lost their job. You're saying the reputational injury is not in Massachusetts?
There may be business injury in Massachusetts. I don't think that there is reputational injury in Massachusetts.
Okay, so there's
per se.
business injury. Is that not sufficient?
When you look at what the Calder court was particularly focused on, it was focused on, again, volitional actions by the defendant directed to the forum state. And the mere fact that you're aware that the plaintiff resides in the forum state and may suffer some injury there isn't sufficient. For example, in the Walden case, you had the Georgia police officer, fully aware, by the way, under the facts of Walden, that the plaintiffs resided in Nevada. He took away about $100,000 of their money in the Georgia airport, and knowing that it would deprive them of that economic benefit within Nevada, that was not sufficient for the court to find personal jurisdiction.
Walden was not defamation.
No, true enough.
It was a much factually weaker claim. But, I mean, take my example. I mean, are you not targeting a Massachusetts business which has Massachusetts employees, which could affect the Massachusetts economy if that business is severely injured? Is that not injury which Massachusetts has a substantial interest enough to say we have jurisdiction over that case?
No, it's not, Your Honor, because the Walden court specifically says foreseeable injury within the forum state is not enough. There has to be a purposeful decision to reach into Massachusetts and conduct activities to reach into Massachusetts and have a relationship between the defendant and Massachusetts, not just a relationship between
Aren't you reaching into Massachusetts when you're attempting to ruin a Massachusetts company?
The case law is very clear that a relationship between the defendant and the plaintiff, who happens to reside in Massachusetts, is not the question. The question is the relationship between the defendant and Massachusetts itself. And that's why the Calder court looked to the calling from Florida into California to get information for the story, talking to residents of California other than the plaintiff. The reputational injury in California among residents of the state of California, as the Walden case further explains.
But what Calder says, California is, quote, "the focal point of the story and of the harm suffered." Could the same not be said here, that Scavenger is the focal point of the story and of the harm suffered?
Well, Scavenger's activity, the Shirley Jones case involves, of course, her alleged, in the case of the defamation in that case, the allegedly defamatory story said that she was unable to satisfy her professional obligations within Hollywood, making TV shows and such, because she drank too much, and that interfered with her ability to contract with those California TV producers and then go and make her show.
It also would have affected her ability to be in plays in New York. I mean, her injury was national.
But here, Level Up's activities are, as they say in the complaint, all over the country. It's not just that Level Up has its business primarily in Massachusetts with Massachusetts customers. The allegedly defamatory statements had to do with its treatment of customer data all over the
But the
country.
consequence on the company could be that it loses revenue, loses jobs, and could potentially go belly up in Massachusetts.
Sure, it is.
And that's not, in your view, sufficient.
That is not, because of the focus of the court's case law on the fact that it has to be a relationship between the defendant and the forum state, not the defendant and a person who happens to reside in the forum state. There's a distinction there.
And you're saying then that the relationship, the targeting of a corporation in a foreign state is not itself a relationship?
No.
That when you go after a company in Massachusetts, albeit without entering Massachusetts, you don't have a relationship with Massachusetts?
No, not in the way that the courts have looked at this in the due process sense. The consequence otherwise would be an astronomical change, I submit, in personal jurisdiction, particularly when you get to the question of internet defamation. The notion here is that so long as you intentionally, defamation is an intentional tort in the sense that you are making a statement intentionally. As long as you intentionally make a statement about a Massachusetts corporation wherever you happen to be, that could cause harm to that Massachusetts corporation, whether in its Massachusetts reputation or otherwise, then you are subject to jurisdiction in Massachusetts. Means that if a college professor in Berkeley gives a lecture where he criticizes General Electric to a bunch of students, or puts something online about General Electric, he can be hauled all the way to Massachusetts, where General Electric happens to be headquartered, because his statements may harm General Electric here. I don't think that is something that anybody would reasonably expect, or that comports with fair play and substantial justice.
But the professor isn't doing any business in Massachusetts. You're drawing on Massachusetts. You're trying to, I guess, get business everywhere. You've got franchisees, right, that are using Punch or Level Up services. When you go to the snack bar down the street, they're using Level Up. You want them to be using Punch, right? The professor doesn't have any of that interest, does he?
No,
or she?
Perhaps not. But that doesn't satisfy the element of purposeful availment of Massachusetts within the facts that are alleged in the complaint. The facts that are alleged in the complaint here are all out of Massachusetts communications.
So if you're trying to just basically eliminate your competitor and drive them out of business, and it's a Massachusetts company, as long as you don't contact people in Massachusetts, you can contact all the headquarters around the country. As long as you don't contact anyone in Massachusetts, you're okay.
Or publish anything in Massachusetts.
Well, I'm not sure that I would go to quite that extreme. And I was trying to think of a law school hypothetical where you could imagine an out-of-forum statements harming a Massachusetts corporation and satisfying the purposeful availment and relatedness tests of personal jurisdiction. So suppose, which is nothing like the facts of this case, you had an out-of-Massachusetts, say a California corporation, hires a private investigator within Massachusetts to follow around the CEO of a Massachusetts corporation. And that private investigator finds evidence he thinks that the CEO is a white supremacist. And the private investigator within Massachusetts relays that information to California, the defendant. The California defendant then communicates that message to Massachusetts customers but who happen to be outside of Massachusetts at the time it was communicated to them. Suppose they're all at a conference together and he makes some defamatory statement. Then, perhaps under the right circumstances, you'd have a situation where the defendant has engaged in enough relationship with Massachusetts itself through the private investigator, which is similar to the Florida phone calls in Calder into California to collect information. You might have a circumstance where you'd meet the relatedness test and the purposeful availment. The Burger King case from 1984 teaches us there are no mechanical tests in questions of personal jurisdiction. You're always looking at the totality of the circumstances under the facts of the case. And the facts of this case, Punch is incorporated in Delaware. It has its principal place of business and all of its U.S. employees in California. No offices in Massachusetts, not registered to do business here. All its U.S. personnel located in California, as I said. No statements even to a representative of a corporation that happens to have its headquarters in Massachusetts. There are none of the kind of hallmarks of purposeful availment and relatedness that the courts insist on in due process cases.
I'm sorry, go ahead.
I was going to say, just ask you, do you think that Calder remains good law?
The way I would put it is that Walden has pulled back on some of the more imprecise language in Calder. While the overall structure of Calder may remain good law, some of the broader applications of Calder have now been pulled back in light of Walden.
Well, you could look at the footnotes in the Calder case, which make it suggests pretty strongly that they're really approving of the effects test, and that almost the kind of defendant's contacts with the forum seem to be an alternative ground that they're less concerned with. And you can see that in Walden that what Justice Thomas seems to emphasize are those physical connections.
I would agree with that observation, Your Honor, and simply say Walden also said the mere fact that the plaintiff suffers the effects in the forum state is insufficient.
On the other hand, in the footnote 9, Justice Thomas writes that we leave questions about virtual contacts for another day.
Yes. I would say this is not a virtual case. This is a case indistinguishable from if Punch had sent these communications via letters to folks in Texas, Tennessee, California, New York. The fact that they were over email or over phone calls doesn't make this a virtual case in that sense.
Before you leave, you argued long-arm jurisdiction on appeal. Where did you ever argue that below?
We argued long-arm jurisdiction on pages 4 through 8 of our initial memorandum of law in support of our motion to dismiss below. It is inaccurate to say that we waived that argument below. Judge Kaplan does not suggest in his order that we never raised that issue. It was squarely raised below, but because this waiver argument was only raised in a reply brief and not in the main brief, we didn't have an opportunity to address that through the normal briefing.
So is that an independent basis on which you're suggesting that we affirm what Judge Kaplan did?
Yes, Your Honor. It is an independent basis that the record would justify affirming Judge Kaplan. As he pointed out in a footnote, the only arguable basis for jurisdiction here is Section 3C, causing tortious injury in Massachusetts through an act in Massachusetts. There has been no act in Massachusetts causing tortious injury.
And in the appendix, what page are you saying pages 4 through 8 are?
Your Honor, it is not located in the memorandum is not located in the appendix under the rule that memoranda are not included in appendices unless there's.
So you're saying it's not mentioned in your motion. You made no reference to the long-arm statute in your motion.
In the motion document itself, no, Your Honor. But we did say there are no sufficient contacts between Punch and Massachusetts, and of course the long-arm statute talks about minimum contacts just as well.
Well, I mean, my concern is that you limited the scope of discovery. You objected to the scope of discovery, and you're asking us to say that under 3D, your contacts with Massachusetts are insufficient. Do we know how much revenue you accrued from Massachusetts, from apps occurring in Massachusetts restaurants?
No, Your Honor, that is not part of the record, and I see your point. The court did allow for limited discovery. It required Punch to answer an interrogatory concerning to whom the statements were made. We did not engage in discovery concerning Punch's overall revenue derived from Massachusetts.
So how do we know whether or not 3D is satisfied without knowing?
Well, Your Honor, I would simply say that discovery is not something that happens in the ordinary course in all personal jurisdiction motions. It is supposed to happen only when the plaintiff has articulated a strong basis to believe that discovery will help aid the motion. And there was not a strong basis made below to suggest that discovery would show that Punch had such extensive contacts within Massachusetts that it is essentially at home within Massachusetts, which is the standard for 3D.
That's not the language of 3D.
No, it's the gloss, as I understand it, that the courts have put on 3D.
At home?
It's essentially a general jurisdiction provision.
Well, you say that. If he regularly does or solicits business or engages in any persistent course of conduct or derives substantial revenue from goods used or consumed or services rendered in this Commonwealth. So the problem I have is we don't know what your revenue model is, whether or not if I use your app at a Chile's or whoever else you have business with, whether or not you get any revenue because I used your app at a Chile's in Burlington, Mass. Or not. So I don't know if you derive substantial revenue from goods used or consumed or services rendered in the Commonwealth.
The only other point I'll make on that subject, Your Honor, and I understand the problem, is that this was not a prong of an argument for jurisdiction that was pressed below. The discussion before the Superior Court had to do with where the allegedly defamatory statements were made.
Okay. Thank you.
Thank you, Your Honor.
All rise.